Ms. Gamble. Ms. Gamble?
The Fourth Amendment does not require warrants. It protects people against unreasonable searches, but it has never, by its language, required warrants.
The Supreme Court has chimed in and said that it does.
The modern Supreme Court interpreted it that way. The language only requires reasonableness, and nowhere does the Fourth Amendment ever say that evidence obtained absent a warrant or even absent reasonableness be excluded. This exclusionary rule wasn't carved out by the courts until 1961. That means for 172 years, the Fourth Amendment did just fine without excluding evidence. The courts decided to impose that sanction. The courts decided that that would be the best way to remedy police misconduct. Now we've stretched it to remedy police mistakes. Innocent mistakes, which themselves are reasonable. If a convicted felon locks up a woman, if he tells her he has guns in his closet, reason says he's forfeited his right to privacy. Reason says those police officers should go in and investigate.
Are you asking me to ignore the holdings of the Supreme Court?
I'm asking you to recognize the absurdity of the exclusionary rule. I'm asking you to recognize how ridiculous it is to require 20-year-old police officers to understand the law when judges and lawyers can't. In this case, there was no misconduct by the officers. They rescued a woman who appeared to be kidnapped. They attempted to make sure the apartment was gun-free before the kidnapper returned. This is reasonable. That man sitting right over there stabbed a nun 30 times and cut her into pieces. He has a felony record. Last night, I got into a screaming argument with the defense counsel. She accused me of making this personal. It is personal. I take my job very personally, Your Honor. I like to come in here thinking the work I do counts for something. Just like those police officers. And when we see criminals get turned loose on technicalities that have nothing to do with merit or the Constitution was designed to protect the innocent, not the guilty. In this case, that man, Your Honor, feed this right into the mouths of the Supreme Court. If they want to spit him back on the street, yes, I'm asking you to overrule recent decisions. We need a brave judge to do that, Your Honor. Otherwise, they'll never get the chance to revisit the irrationality. He killed a nun. He mutilated a nun and stuffed her into a closet. Fourth Amendment was never meant to protect this animal. I'm sorry. It's personal.
I agree with Ms. Gamble. There is nothing in the language of the Fourth Amendment that requires warrants. Nor is there anything that says illegally obtained evidence should be excluded. These rulings have been carved out by the courts in response to our distrust of the police. I also realize the courts are more than willing to adjust their thinking to the needs of the day. We search bags at airports now without warrants. Make people go through metal detectors. California requires fingerprints just to get a driver's license. The Department of Transportation has mandatory drug testing. We have all these invasive things we do to people, absent not only warrants, but absent any suspicion of wrongdoing. So, why can't a police officer who's been told there are weapons in the closet of a convicted felon, a man suspected of kidnapping, why can't he open the closet? I agree with the district attorney. The Fourth Amendment has been interpreted and expanded by the courts to the point where it belies both the language and the intent of the amendment, which is reasonableness. But I also know the Supreme Court rulings on search and seizure have set clear rules. And as much as I would love to be a renegade, our criminal justice system has no chance whatsoever once the judges themselves begin embracing judicial anarchy. The search of the closet was illegal. The contents are inadmissible. With the contents suppressed, I find no probable cause to hold the defendant. He is free to go.